Heary, heary, heary. Colorado Court of Appeals is now in session.
Please be seated. Good afternoon. Welcome to Division 4 of the Court of Appeals. My name is Judge Furman. This is Judge Miller, and this is Judge Kopelke. We have two cases on the 1:30 docket and one on the 2:30 docket. It looks like the lawyers are ready on all three of those cases. You should have been provided with a handout of our procedures. And obviously, I think you received an order directing that the three cases be set together for a single argument. If anyone in the courtroom has a cell phone, please make sure it's off, and let's begin.
May it please the court. I'm Britt Clayton with the firm of Riley, Carlock, and Applewhite, registration 15940, appearing on behalf of the appellants Meyer, Rhoden, and Spicer et al. There are three distinct legal elements in these cases under the residential land classification statute: contiguity, common ownership, and use as a unit. Each of these elements is disputed in one or more cases today, and each element was recently addressed in published opinions from other divisions of this court, which I will discuss. I'm going to begin with the used as a unit element, which is disputed in the Meyer and Rhoden cases today. It's undisputed that in the Meyer and Rhoden cases, if the exact same land was in a single parcel rather than two parcels for each family, the used as a unit element would be presumed satisfied for 100% of the land. The fundamental question this court has to answer is, should the used as a unit language in the statute be construed differently where there are multiple parcels rather than one? Of course, we start with the language of the statute. We see that a parcel of land and contiguous parcels under common ownership are grammatically interchangeable. They're treated the same. All of the language that follows the parcel language is the same, and it applies equally to both situations. Second, we look at the case law. In the single parcel context, Gurman and Farney collectively hold that merely keeping other people off the property and looking at wildlife is legally sufficient to satisfy the used as a unit element for the entire parcel, assuming no non-residential use exists. The logic of these cases readily extends to the multi-parcel situation, because homeowners use their lands in fundamentally the same ways, regardless of whether they have a single parcel or a multi-parcel assemblage. Fifield holds that in a multi-parcel case, if there is a residence anywhere on the assemblage, that's sufficient. It's not necessary to have residential improvements on each parcel. Fifield noted that its ruling was consistent with Gurman and Farney, which reflects an appropriate desire to harmonize the interpretation of this statute in single parcel and multi-parcel cases. So the statutory text, existing case law, and the way that homeowners actually use their lands all suggest that the used as a unit element has the same meaning for single parcels and for contiguous parcels under common ownership. The recent opinion from Division 6 in Rust versus Summit County holds that the multi-parcel situation should be treated differently, and something more than occasional use and deriving peace and serenity is necessary for an undeveloped parcel to be used as a unit with the residents. With due respect to Division 6, Rust was incorrectly decided as a result of two fundamental errors. First, Rust erroneously concludes that the Fifield and Sullivan cases hold that occasional use and deriving peace and serenity are insufficient. That issue was not presented or decided in Fifield. Fifield held only that improvements on the adjacent parcel are unnecessary.
Mr. Clayton, I'm sorry to interrupt, but
Please do.
my question is maybe a more fundamental one. And to what degree, and I think Gurman suggests this, but to what degree do we defer to the BA's fact-finding?
If the BAA applied the correct legal standard, and its findings are not clearly erroneous under the well-known standard, then, of course, the court defers to the board's findings. In this case, if I may, the board quite evidently adopted the assessor's erroneous interpretations of the statute, made findings which maybe should be viewed as conclusions, but to the extent they are findings, they are clearly erroneous. And this is all detailed in the deconstruction of the BAA's ruling in our opening brief, and then further in our reply brief, where we address this very issue about to what extent is this factual. The undisputed facts in Meyer and Rhoden, if they were single parcels, would absolutely undisputedly support residential classification. The only way you can get to the conclusion that they do not is to establish a different principle, a different rule, a different meaning of this term in the multi-parcel context, and that is a pure issue of law on which the board and the county assessor and respectfully Decision 6 erred. Judge Miller, I see you.
Well, you say that those facts would undisputably support a finding, but that doesn't mean they would necessarily require a finding in the favor of the taxpayer, does it? Doesn't the BAA have to consider all the facts that are before it?
Well, I beg to differ. If the facts are sufficient as a matter of law to satisfy the statutory element, it's not up to the BAA and it's not up to the assessors to say it doesn't feel good enough to us. Bear with me for 1 second. If Gurman applies, right, in the multi-parcel context, that case holds clearly it is sufficient to establish the residential use of the property merely to keep other people off of it and to look at wildlife. The procedural posture of that case is very important. The BAA had found that those facts were sufficient. The county appealed. This court said those facts are legally sufficient to satisfy the statute. Now, what it means to have a holding in stare decisis and a principle of law is that when someone else comes along presenting the same facts, they get the same treatment. They don't get arbitrary and capricious decisions. Your view isn't good enough. You can look this way. Just don't look that way where that house might be built.
Are there no fact findings then that could be, are the fact findings somehow binding?
Well,
I didn't put that right. In the context we have here with cases, we have the testimony of Mr. Cassidy, which gets accepted by the BAA, and challenging whether, in fact, particular views are affected and so on. Why aren't those fact findings based upon conflicting evidence that they've resolved?
Well, first of all, the assessor admits in his testimony that a house on the subject parcel, I'm talking about Rhoden now, a house on the subject parcel would constitute an impairment and a significant change for the worse in the view in that direction. If you look at the aerial photos of the layout here, it's obvious, these big houses right next door to each other. There's going to be some impairment. You don't have to check your common sense at the door when you put on your robes. What the county and the BAA are doing is saying that's not good enough. It has to be a direct and necessary use of the parcel. Merely trying to maintain your peace and quiet and preserve your views and not having a neighbor is not good enough. They're just fighting Gurman. Or more accurately, they're saying it doesn't apply. In the multi-parcel context, we get to decide what the rules are. So sure, the BAA makes findings that it's likely the Rhodens would sell the property in the future. Admitted, he testified to that. But it's legally irrelevant. It's not the right standard. Sure, the assessor says, you've got a great view of the Saguache Range. You don't have to look over here. True, but who gave him license to say what's important and what's not? Gurman is a great decision because it recognizes the way that people actually use their lands, particularly these larger parcels or assemblages, right? When you have a little land, you just want elbow room, and that's good enough.
So all it's necessary is for the landowner to say, yeah, I like the view, and that's the end of it. The board is required to accept that statement.
Well, I can envision situations, and there's been hypotheticals discussed in some of the briefs, where there would not be a residential use. For example, a developer, owns several lots, puts a house on one, and doesn't even live there. So it's not that anybody saying they have a use, it won't be tested by some sort of reality check.
So if you have someone who testifies that their crucial consideration is preserving the view, and at the same time they're trying to sell the property, and the BAA makes a fact finding that under those circumstances, we're not going to lend credibility to their description of how they want to use the property. Can they
Well,
do that?
I suppose they could. I mean, even a rejection of testimony has to have some rational
Sure.
basis in the record. It can't be totally arbitrary. But, on a highly simplified hypothetical like that, I suppose. But look, these cases have testimony by the assessor echoing what the homeowner says, findings by the BAA echoing what the homeowner says. The BAA doesn't say, Mr. Rhoden was a pathological liar, I accept nothing he says. When you read that carefully, what the BAA is saying is, yeah, you got a view over here, but we don't think it's important enough. Yeah, you got privacy, sure, but we don't think it's good enough, because they're not applying Gurman. Gurman's a very low bar. And yes, if credible, and these are totally credible records and testimonies, if credible, somebody saying, I want elbow room, I want to keep other people off and make my property twice as big as it otherwise would be, that is good enough as a matter of law if that's believed, and it's undisputed here, it's undenied here.
Is Gurman binding on us?
Well, no Court of Appeals opinion is binding on any other
Right.
panel in any kind of rigid sense. But I think stare decisis is a valuable concept. And it's not only Gurman, but it's Farney, which provided sort of the flip side of that. If there's no non-residential use, then we presume it's 100% residential use. That's an important concept here. And I think Farney Fifield, in the multi-parcel context, looking to those single parcel cases and trying to harmonize things and saying, see, it all works together. That's how the law develops. That's stare decisis, and I would respectfully ask this court to follow those well-established precedents. The General Assembly has had an opportunity to modify the law if it didn't like that, and it has not. The more recent Rust precedent, I think, is even less subject to deference. I do hope that this panel will independently reach its own conclusions on Rust and its implications for this case. But I believe that Rust erroneously treated Fifield and Sullivan, and more importantly, held that the ARL reasonably imposes an additional requirement that the undeveloped parcel must be integral to the residence. This is an astounding holding, and there are multiple problems with it. First, the word integral doesn't appear in the statute. The DPT has no authority to add a new requirement in the ARL. That's the Rust Court's terminology, not mine, new requirement. I think I may have misstated that. I think it's an additional requirement. The additional requirement, pardon me. Additional requirement. The Rust opinion finds it reasonable to impose this additional requirement of integral use based on its reading of the ARL, but it's inherently unreasonable and not permitted to violate the canon of statutory construction that we don't add words of limitation to a statute that the General Assembly declined to add. Now, in defense of the Rust panel, it was at a disadvantage on this issue because it did not have the benefit of the testimony of Kurt Settle, the deputy director of the DPT. Rust makes no mention of his testimony because he didn't testify in that case. In fact, he didn't testify in the Summit County cases. We only started calling him in the Eagle County cases we're here on today. In the Eagle County cases that were tried later, including Meyer and Rhoden, we called Settle to clarify what the DPT means. And here's what he testified to in the record in this case on this integral issue in the ARL. Question, Mr. Settle, in the second bullet point, the word integral appears, but that term doesn't appear in the statute, does it? Answered, it does not. The statutory phrase is used as a unit, or if you want to read the whole thing, used as a unit in conjunction with the residential improvements. Answer, correct. If I just say used as a unit, that's a shorthand for that whole element, okay? Yes. In the ARL, is the word integral simply used as a synonym for used as a unit? Answer, yes. Do you understand that the word integral can have different meanings in other contexts? Answer, sure. Do you understand that one possible meaning of integral is necessary or essential, which the county has argued? He says, I've heard that argument. Question, but that's not the meaning that's intended in the context of this ARL, is it? The intent is that integral and used as a unit in conjunction are synonymous, as we have just discussed. Question, to your knowledge, is there any support in the ARL or in the statute for imposing a requirement that the use of contiguous parcel must somehow be essential or necessary in order to satisfy the statute? Answer, those words are not in the statute or in the assessor's reference library. That's the Meyer transcript at 50 to 52, and the same testimony appears in Rhoden at 103 to 104 of the transcript. These passages were not called out in the briefs, but the division's recent opinion in Rust, the other division, brings out the importance of this testimony of the deputy director of the DPT saying integral is not an additional requirement. It's just a synonym. So this whole foundation for the Rust opinion about adding a new additional requirement to the statute, it violates a statute, a principle of statutory construction, and it's not supported by the DPT itself in interpreting its own guidance. The root of the problem on this issue is that the appellees and the Rust division are engaging in meta-interpretation of the ARL instead of direct interpretation of the terms of the statute. It's like writing a dissertation on the cliff notes to Moby Dick instead of on the novel itself. This whole discussion of what integral means in the ARL has done nothing but divert our attention from the statutory language, which should be our touchstone. We ask this panel to reject the suggestion that the ARL imposes or that it could lawfully impose a non-statutory additional requirement for residential classification in the multi-parcel setting. The statutory language reflects a clear legislative intent to treat commonly owned parcels the same as a single parcel, and applying Gurman and Farney here, the used as a unit element is plainly satisfied as a matter of law based on these undisputed facts that we've discussed. Turning to common ownership, all three of the cases today have a disputed common ownership element. On this issue, Division 5 recently issued a very cogent opinion in Kelly versus Summit County, holding that in the property taxation context, a determination of ownership is not limited to consideration of record title. Rather, ownership depends on who has the right to possess, use, and control the property. In the interest of time, I'm not going to reiterate the legal reasoning of the Kelly decision, but we do endorse it and adopt it insofar as it goes. From a factual standpoint, Kelly is on all fours with the Meyer case presented today. In Kelly, the residential parcel was owned by a Cupert trust, and the subject parcel was owned by a revocable family trust. After analyzing substantive trust law, the Kelly panel concluded that Ms. Kelly had the right to use, enjoy, and possess both parcels, and hence she was the owner of both parcels. The same analysis applies with regard to the Myers' title to their residential parcel in their Cupert and their title to their subject parcel in their individual names. Simply following Kelly leads to the same result on the common ownership issue in Meyer.
Now,
Now,
let me ask a question about what, I'm not exactly sure you would draw the line with ownership. Is it enough that, well, take the case of the Myers. On January 1 of 2016, which is one of the years at issue, they were going to lose that property in a year and a half under the terms of the trust, right? The trust terminated in a year and a half.
some of these analyses will change based on trust terminations, for example.
So it's good enough that they have ownership, quote, ownership for a year and a half, even though they have fee ownership. You don't have to have fee ownership. It can be just an interest for a term of years.
Correct.
Where do you get that from?
Well, drawing specifically on the Cupert analysis, which you could characterize as, you know, an interest for a term of years, the fact that the trust terminates does not alter the fact that on the valuation or assessment classification dates, as they come up during the period of the trust, the element is satisfied. The ownership is the same. We have changes in ownership all of the time. You know, most of them are reflected by record, but using the analysis from Kelly, there could be some instances where a taxpayer could show that there had been a change in ownership by virtue of a change in a trust instrument, a partnership, a will, any number of changes. And Kelly just appropriately says we have to look at the true substance of what's going on January 1 of the assessment date.
In another case, you have, in the Rhoden case, at least in the first year, Mr. Rhoden owns and controls the entity that owns the residential property. However, Mr. Rhoden and Mrs. Rhoden own the other property.
Yes.
How is that common ownership?
Well, it's common in the same way that we may have common ancestors, but they're not all the same, or else we'd be siblings. We may have common interests. Having something in common doesn't mean that it's 100% in common, number one, just as a common usage of the term. And we have cited numerous cases and statutes that have interpreted the term common ownership to simply involve a non-trivial overlap in equity ownership and control. I didn't make this up. We just found all these cases that say that use the term that way, and it has its own meaning in legal parlance by virtue of being used in statutes and cases in the way that I'm saying.
From other states.
Well, and Colorado. There are cases and statutes from Colorado that use the term common ownership in the expansive way that I'm talking about. Now, everything can be distinguished on the basis that it's not this case, but that term has a real, live, definite meaning in American law, Colorado no exception. And it includes the kinds of overlapping, non-identical ownership and control. What I would say before I move off of this topic is Kelly is a great, appropriate tool to get into the question of who's really the owner here? Who's really the owner here? And the question of commonality is the question of the overlap. So in Rhoden, we have Mr. Rhoden, half owner of one parcel, and effectively the whole owner of the other parcel through his LLC. You have a 50% overlap. In Spicer, you have Mr. Spicer being the 50% owner of one parcel, the 25% of another, and 50 of another in his individual name. There's commonality and overlapping right there, and you have other interests that add to that. So Kelly is a real breakthrough in terms of we're not stuck at record title. When you look underneath and find out what ownership there really is, commonality just means non-trivial overlap.
What's the definition of non-trivial?
There would be gray areas and gray cases someday presented, I have no doubt about that. But that is intrinsic to the General Assembly's use of a term that uniformly encompasses overlapping ownership interests non-identical. Maybe they should not have used that term, but they did, and it has a very clear meaning in the law. I am going to skip the contiguity. Let me say one thing about contiguity in the Spicer case. Only Spicer presents the contiguity issue. I would love to talk about the Bringle opinion and why we disagree with its treatment of contiguity, but there's an easier resolution of the Spicer contiguity issue. And that is, it doesn't require disregarding an intervening way or driveway. Spicer also independently involves this concept of contiguity, which is a continuous boundary surrounding the assemblage. So just like the 48 United States are contiguous, despite the fact that no state touches all of the others, these 3 parcels are contiguous because they have a boundary that is continuous all around them. You don't have to disagree with Bringle to get to contiguity on that basis. However, Bringle is incorrect, and the Spicer situation also establishes contiguity on the close proximity theory that we have fully briefed.
And you're saying that Mr. Spicer's 25% interest in the common property is non-trivial,
Correct.
even though he doesn't control, he has no control whatsoever.
Well, the 25% interest is in the common parcel that's actually
That's what I'm
the
referring to.
right-of-way, yes. Mr. Spicer alone does not control the common parcel. He and his partner have equal control with the other owners, and all of them have a right to use and possess and enjoy it.
Thank you.
Thank you. I'll reserve my remaining time.
May it please the court, my name is Christina Hooper. My attorney registration number is 38271, and I'm an assistant county attorney for Eagle County government. I'm here today on behalf of the Eagle County appellees. I will be sharing my time today with Mr. Evan Brennan, who is counsel for the Board of Assessment Appeals, so I will reserve some time for him as well. As I proceed, I welcome any questions from the board, or excuse me, from the court. The issue in these cases is whether the unimproved parcels of land owned by appellants were misclassified for these tax years spanning between 2013 and 2016. If these properties were misclassified, then these appellants are entitled to a refund of taxes with interest at the rate of 1% per month. Because there are so many of these cases pending, and they all are based on we assert, novel interpretation of the definition of residential land, this matter is of statewide concern, and it not only has an impact on county governments, but all taxing entities that provide services to our communities. In light of the recent opinions of a panel, different panels of this court in the Rust, Bringle, and Kelly cases, I would like to focus on 4 issues today. The first being the application of the Kelly decision on the question of common ownership here in these cases. The second being that under the standard established by the Rust case, the BAA did correctly conclude that the Meyer and Rhoden uses did not satisfy the use as a unit element of the statute. Based on just some questions I've heard today and opposing counsel's argument, would like to explain why Rust is the correct interpretation of the statutory requirement. And the last thing is to talk about whether the board's decision on the Spicer use as a unit, in terms of it being just a view, had a reasonable basis in law. The common ownership issue under the Kelly standard has been announced that record title only creates now a rebuttable presumption of ownership. But we assert that because the petitioner failed to meet the burden to show that the ownership in these cases was the same in substance, that the board's decisions in these cases should stand. The Meyer case, there is a distinction in substance and the ownership. There is a great difference between joint tenants holding title to one property and two qualified personal residence trusts, or QPERTs, holding another property as tenants in common. Unlike the Meyer case, the expert testimony unlike the Kelly case, the Meyer testimony that the Meyers were the beneficiaries of the QPERT trust did not go undisputed. The county presented evidence that shows that actually in substance the ownership is very much different. The trust was irrevocable. The beneficiaries were the children, while the Mr. and Mrs. Meyer, joint tenants of the subject parcel, had the right to live in the residence for a period of years. They were not able to convey that property. They were not able to take any action with respect to that property outside of the confines of the trust. Generally speaking, practitioners in this area consider once a asset like this property is conveyed to a trust, the trust becomes the owner, and the person conveying the trust has lost their ownership interest in the property. The IRS indeed considers these things to be separate in substance. In fact, there was testimony that it would have potentially destroyed the trust to have this additional land that may have been determined not reasonable for residential use added into the residential trust. So what the evidence shows that we do lack the crucial incidents of ownership here. The Meyers, if they were to try to sell that property, they basically would have had to buy the property back from the trust, replace that property with something of equal value, and then they could convey the property. Basically what they had was the equivalent of a lease. Clearly, the intent of the legislature for these tax statutes is not that a tenant is considered one and the same as an owner. In fact, a panel of this court has decided in the Traer Creek case that that is not the case, that a lessee is not the equivalent of the owner. In the Rhoden case, we have joint tenants on one hand and an LLC owning the residential parcel on the other hand. The evidence shows that there are differences in the incidence of ownership there as well. We know that Mr. Rhoden, who was one of the joint tenants, also was the manager and the sole member of the LLC, but there's no evidence about Mrs. Rhoden's right to control that residential parcel. In fact, under Colorado law, the manager and the member is not the owner of the property unless the corporate veil is pierced. The manager has the ability to bind the LLC. The members are entitled to the proceeds or profits from the LLC, but the owner under Colorado law is considered to be the LLC. Also, it just as a matter of common sense, both the bank and Mr. Rhoden's legal advisor considered the ownership to be different. They purposely put them in different ownerships for a reason. But moving on to the Spicer case, it's quite a bit more complicated. The county agrees that there is a common thread of ownership between the subject parcel, the residential parcel, and the intervening parcel. However, even under the Kelly decision, there is no commonality in the right to control these parcels. In addition, one of the intervening parcels has a greater ownership interest in a non-party to this case. The very distinct ownership structures here raise quite a few questions even under the Kelly standard. How much interest would be enough if a common thread of ownership was to be accepted as common ownership under the law? It would leave assessors without any certainty in trying to make these determinations. It also conflicts, we think, with statutory language as a whole. The example that we have in the Spicer case with related parties owning bits and pieces of these assemblage, as Mr. Clayton has described it, is a kind of scenario that the legislature considered with the definition of hotel and motel units. Hotel units under CRS 39.1.102 5.5 actually considers the issue of control and related parties, and it's very expressed that it's only for purposes of that definition. If the legislature intended this common ownership concept to extend to a common thread of ownership, like we have in the Spicer case, I think they would have used the same type of statutory language. Even though these cases are distinguishable from the Kelly case, we respectfully ask this court to decline to follow the Kelly ruling for 4 reasons. First, the Kelly decision contradicts in holding that record title is not determinative and it just creates a rebuttable presumption of ownership, conflicts with the statutory scheme as a whole. The legislature used the word ownership in several different places, or owner in several different places, and none of which evidence any intent that it's creating a rebuttable presumption. So under 39.1.102, 14.4, we have common ownership. Under 39.5.102, we have the provision that it's mandatory that the assessor shall determine ownership from the records of the clerk and recorder. The unit assessment rule at 39.1.106 requires the assessment to be to the fee simple owner. The fee simple owner is assessed, not those with lesser interests in the property. 39.5.104 contemplates multiple parcels being owned by the same person, and then person is defined within that statutory scheme as a person or an entity which may become a taxpayer by reason of the ownership of the property. So even in that definition, the legislature is recognizing that the owner is the entity and that we're not supposed to dive beyond record title to find out who might have some incident of control. Kelly also conflicts with the Sullivan standard, which we do not agree is dicta. The Sullivan court was looking at that very question of whether common ownership needed to be in the same name of 2 separate owners of separate lots, and determined that the board's decision that the Sullivans did not qualify for residential classification was based on the fact that the properties were not in the same name, and the court expressly affirmed that decision and rejected any assertion to the contrary. Also, we think it conflicts with the Traer decision that I've mentioned, that ownership, after an analysis of the statutory scheme as a whole, the Traer court has determined that record owner is the owner. That's what ownership means, not somebody who has just possession or control or an interest in the property. Third, the Kelly decision relies heavily on the reasoning from the HDH opinion of a panel of this court. And in that case, at this point, the Supreme Court has accepted cert to consider whether the court erred in determining record owners of real property are not the true owners for purposes of property taxation. We think that the HDH opinion relied on case law that relates to the very unique situation for the assessment of ownership interest or interests in tax-exempt property. So possessory interests in tax-exempt federal or state property has its own specific place in the law, but those cases shouldn't be extended to interpret the ownership requirement here any differently. We also think that the Kelly standard would be it's contrary to the requirement that these tax statutes are strictly construed in favor of the principles of uniform taxation. Without knowing with certainty who the owners of these properties are, it leaves too much to question. We're not sure what would end up, the commonality standard would end up being, what percentage of ownership is enough. And really what it could effectively do is create a situation where the assessor is in the position of anybody who brings in a statement that the true owner is not the record title owner would be either required to have a legal staff to dive through and conduct discovery to figure out complicated ownership structures, or just effectively accept the word of the property owner or the person coming in asserting the ownership. Moving on to the used as a unit in conjunction with residential improvements standard, we disagree with opposing counsel's statement that the Russ decision is incorrect. It did not make any erroneous conclusions of law or interpretations of the statute. It is very reasonable that the ARL requires or interpreted this provision to simplify the provision, to say the use has to be somehow integral to the residential
Does that mean
use.
essential?
Integral means, it means necessary, it means important to, it means a unit. It needs to be something that is beyond subjective.
So it doesn't have to be essential.
I don't interpret it any farther than I think it means necessary, it means important, it could mean essential. I think that it has to be connected as a unit. I think that the factors that the Department or Division of Property Taxation has set forth are very reasonable questions for an assessor to ask to see if the properties really do function as a unit. I think the function and the actual use of the property is something that has to be tangible and seen.
But doesn't that, the meaning that you're giving integral, doesn't that expand upon what the statute says? The statute doesn't say that.
Well, I really don't think that it does if you look at the statutory scheme as a whole. So we know from the Constitution that residential real property must include all residential dwelling units in the land as defined by law. And then we know from the Vail Associates case that was cited in the Board of Assessment Appeals brief that a residential real property as a single unit must have a dwelling unit. Not just an improvement, but it must actually be a dwelling unit. And then to read the definitions in section 39.1.102 together, subsection 14.3, 14.4, and 14.5 together, it is a very reasonable interpretation reading this together to say that the residential land needing to be used as a unit in conjunction with residential improvements implicates some sort of integral use. The definition of residential improvements is a building or portion of a building designed for use predominantly as a place of residency. It goes on to say the term includes buildings, structures, fixtures, fences, amenities, and water rights, which are an integral part of the residential use. So it's incorrect to say the word integral shows up nowhere in the statute. Within the statutory scheme, this is the intent. The legislature requires that even a residential improvement, for it to be a residential improvement, it must be integral to the residential use. I think a reading of this statute together as a whole also is instructive in terms of the difference between a multi-parcel case and a single parcel case. There is a great difference to read Geierman to say that all multiple parcel cases must be treated exactly the same would be ignoring the fact that a single parcel case must contain a residential dwelling unit. A single parcel case could not just have a fence that somebody says was somehow integral to their residential use. It has to have that dwelling unit first. And so this requirement that there's a residential improvement on contiguous parcels, I think this also supports the Sullivan interpretation where there is a split between Sullivan and Fifield in terms of whether there actually needs to be a residential improvement on the contiguous lot. I think had there not been that need, the legislature would have said the contiguous parcel just could be used as a unit with a residential dwelling unit, but they purposefully used the more expansive residential improvement. To discuss the Meyer and Rhoden cases briefly in terms of the use asserted by the property owners in those cases, all of their claimed uses were disputed and based on the information that the assessor could ascertain. I think that it is contrary to opposing counsel's argument in classification cases, the finder of fact is never required to accept as dispositive undisputed evidence because the finder of fact can consider all the circumstances and make reasonable inferences that may tend to weaken or discredit those. The holding has been announced in the Hep v. Boulder County assessor case and the Weingarten case. In the Meyer and Rhoden cases, the testimony was it was discredited. We had property owners saying that they were really protecting one view when their houses were oriented to spectacular views on the other, going the different direction. The testimony then sort of shifted during these hearings to, well, it's just that we really like the aspen grove on that property, or there's just something else we like, even though all reasonable evidence is showing that isn't the primary purpose of the subject lot, that the primary view, for example, might have been to the Saguache Range and not the Gore Range to the east.
Is there a primary purpose test?
There is not a primary purpose test under the statute. The ARL asks the assessor to consider what is the primary purpose. I think it's just important to try to figure out, from an objective standpoint, whether property is being used. In all classification contexts, regardless if it's agriculture or residential, the issue that the assessor has to I guess the evidence the assessor needs to consider has to be objective and tangible and able to be seen. If not, I think that we have a uniformity in taxation violation. The fact that in the Spicer case, turning to the Spicer, the board did indeed find that the view that was claimed was a use as a unit. While Eagle County did not cross-appeal that decision, we do not think that that was a reasonable conclusion or reasonably based in the law. There was highly conflicting evidence presented about those views, and the BAA did not address sort of the ARL interpretation about the factors for consideration. And we submit that if this court were to find that there was to be some sort of common ownership in the Spicer case, that as an alternative grounds, the board's ruling declining to reclassify the property should be affirmed, because a view alone cannot satisfy the used as a unit in conjunction with residential improvement standard. If there are no questions of me at this point, I would like to turn this over to Mr. Brennan.
Good afternoon, and may it please the court. I am Evan Brennan, registration number 49887, and I appear before you today on behalf of the Board of Assessment Appeals. As you have by now heard from both opposing counsel and counsel for Eagle County, the statute at issue today in all three cases before you requires that in order for a piece of land to qualify as a residential without itself having a dwelling unit on it, it must meet three statutory criteria. That is, it must be contiguous to, under common ownership with, and used as a unit in conjunction with a residential property that actually does have a residential dwelling unit. One of those issues, common ownership, runs through all three cases before you today, and thus I will begin there. I would also like to address the used as a unit element quickly, which is an issue in two of the three cases, and if time permits, I'll then turn to the contiguity element, which is only an issue in one case, and under the unique facts of that case is really bound up with the common ownership issue. As the court also by now knows, another division of this court issued a published decision last week in another case filed by Taxpayers Council, that being Kelly v. Summit County. And I'd respectfully disagree with the division's analysis in the Kelly decision, but frankly, that decision need have no bearing on this division's analysis of the common ownership issues at issue in any of the three cases before you. So even if Kelly was rightly decided, and again, if time permitted, I would like to discuss why we believe that it was not. But if it were, I'd posit that it's not in any way determinative of the cases before you. All three cases are eminently distinguishable. In Kelly, one individual woman, Ms. Karen Kelly, set up two distinct trust entities to hold her two properties, and the Court of Appeals concluded, based on undisputed evidence, that she was the settlor, the trustee, and the beneficiary of both of those trusts. and thus both the legal title holder and the equitable owner of both of those trusts. And relatedly, that Ms. Karen Kelly, the individual person, used, possessed, and controlled both of those lots and enjoyed the traditional benefits of real property ownership. Now, to start with, and to show sort of the limits of that holding, I think the Rhoden case is about as far as that as you can get within the three cases that we have here today. In Rhoden, unlike in Kelly, we have a married couple, Mr. and Mrs. Rhoden, who own the subject parcel as in a joint tenancy. So they're both co-owners of the lot in its entirety. And for the residential lot, for the one tax year at issue, 2015, Rhoden Properties, a Missouri LLC, purchased and owned that lot. So instead of the trust instruments in Kelly, which were set up by the same person, and the testimony of that hearing led the Court of Appeals Division to determine that Ms. Kelly was essentially the owner of both of those properties. Here in Rhoden, you have an LLC that's the owner. Instead of the single person overlapping, you have two people, Mr. and Mrs. Kelly, who own it as joint tenants. In Colorado, of course, a legal entity such as an LLC is separate from its members unless there's some reason, and there was none given, to essentially consider the LLC to be the alter ego of its members. So Mr. Rhoden, under presumably prudent advice from his own attorneys, explicitly decided to purchase the land in the name of the LLC, and there's really no reason to determine or conclude that he, Mr. Rhoden, as an individual, owned the residential lot for 2015. So it'd be anomalous.
Was there evidence that he was building the house for his own use and his family's?
That's correct, Your Honor. He was, or I should say the LLC was, for the use of its member, Mr. Rhoden, and his family. But nonetheless, I don't think that confers sort of an alter ego relationship. You know, there's no evidence that they were commingling funds or whatever the other indicia that one would need to determine that there was an alter ego. Here in Colorado, of course, it's corporate governance is not merely a legal nicety. It's a formality that is respected. And even if we decided to, even if one decided that one should disregard the corporate form and consider Mr. Rhoden, the individual, to be the owner, that only sort of gets you half of the way there, because then for the subject lot, you still have Mr. Rhoden and Mrs. Rhoden as tenants, joint tenants who own that lot. So I still don't think you get to sort of the Kelly situation where there's identical ownership. And of course, that gets to the point where, the point that in Kelly, the court expressly decided or declined to decide the issue of what is common ownership as used by the statute, and instead relied merely on the fact that there was identical ownership. The court decided that Ms. Kelly was the owner of both lots. So you still don't get to you still don't have common ownership, even if one assumes that Mr. Rhoden is in fact the owner of the residential parcel. So for that reason, the court should affirm the board's conclusion that the lots were not under common ownership for tax year 2015. And that finding was based on both a different record ownership of the lots and the substantively and significantly different corporate or different structured ownership. Turning to Spicer, you have a similar situation. Again, these aren't trusts. This is a corporation that owns 50% of the subject parcel, along with Mr. Spicer as an individual. That corporation, Glenline Development, has no ownership interest in either the residential parcel or the intervening parcel. So there is indeed a thread of common ownership, to use the terminology adopted by opposing counsel, but there certainly is not identical ownership as there was in the Kelly case, and nor, in my opinion, is there common ownership, again, because really just had Mr. Spicer owning 50% of the subject and 50% of the residential parcel. And the other owner is a different entity on both sides. And finally, in Mayer, I know that opposing counsel indicated that in his opinion that was on all fours with the Kelly decision, but for the reasons given by Eagle County's attorney, I would disagree with that conclusion. Again, going back to Kelly, you had 2 trust instruments set up by the same person, and according to the court, the exact same grantor, trustee, and beneficiary. Here, for the residential parcel, you have 2 KPRTs that own it as tenants in common. And as Ms. Hooper indicated, there was conflicting testimony on who the actual beneficiary was of that trust, both of those trusts. And although we can't know for certain, since it wasn't part of the record, presumably that those trusts have, the term of those trusts have concluded, going to Judge Miller's question, and the property therein has actually passed to the beneficiaries, the children. And then, of course, for the subject parcel, that's owned as in a joint tenancy with Mr. and Mrs. Mayer in their individual names. So again, I think it'd be impossible to sort of conclude, to simply overlay the Kelly holding on top of the facts in the Mayer case and conclude that the one is determinative of the other. Although my time is running short, I would like to briefly touch on the used as a unit in conjunction with element. Contrary to opposing counsel's arguments against the Russ decision, the fact is that the use of the subject lots in the Rhoden and Mayer cases before you today was just as minimal as it was in those cases, and that's a well-reasoned decision. Similar to the Russ case, the Rhodens contended that they used their vacant lot for merely for things like walking, winter recreation, sledding, snowshoeing, views and privacy. And similarly in Mayer, it was purported uses like walking, views and privacy. I think going to Mr. Clayton's characterization of the Geierman and Farney opinions, I do want to touch on that. I think that that's essentially a vast overstatement of the holding therein. I don't think that either of those cases stands for the sweeping proposition that petitioners contend that they do, that simply keeping people off land is sufficient as a matter of law to confer residential classification. Both of those cases were single parcel cases, so they're distinguishable on that grounds alone, but to the extent that they're applicable here, the holding of the court in those cases was that the board's factual decision that the whole acreage in Geierman, I think it was 37 acres, and in Farney something significantly more, 200 some, I believe, or 320, were supported by competent evidence and cannot be disturbed on appellate review. So to the extent that those cases are really applicable here, they stand for the proposition only that the board's findings as to how much of a lot or how much of a property is used in conjunction with a residential dwelling unit is entitled to deference and won't be disturbed so long as it's supported by substantial evidence. I see that my time is running out. Unless there are questions from the panel, I'd like to thank you for your time and respectfully ask that the court affirm the board's orders here. Thank you.
Returning to the used as a unit element first, Judge Kopelke asked if there's a primary purpose element in the statute, and of course there's not. Ms. Hooper correctly said that there's primary purpose language in the ARL. Let me read it to you. One of the things that assessors are directed to consider is the primary purpose of the parcel and associated structures to be for the support, enjoyment, or other non-commercial activity of the occupant of the residence? The answer to that question in all of these cases is yes. These properties serve no purpose except to enhance the enjoyment of the occupants of the residence. The ARL recognizes that. It's not just Geierman and Farney. Now, I understand the practicalities of appellate judging. Not every judge reads the entire record, and maybe no judge reads the entire record. I implore you each to please read Kurt Settle's testimony on interpreting the ARL. If you're going to put any weight on it whatsoever, we need to be clear as to what the division thinks it means and does not mean. Mr. Settle was really clear. Homebound people who can't go out and touch the trees can enjoy them in a way that may satisfy the statute. It's a very an open, encompassing, and real appreciation of the way people use and love their land. And that's really most of what's getting lost in this whole discussion. All these hyper-technicalities about, well, they're tenants in common, and we have to pierce the LLC veil and everything. These people are not gaming the system. My clients are not trying to pull a fast one here. This is the way that normal, real families structure their lives and their ownership, the way they enjoy their properties. And sometimes they have to cross over a little something to get from one to the other, and it doesn't prevent it from being their homestead, their assemblage. These hyper-technical excuses are ways of disqualifying people who are just like every other family, except they have 2 parcels. Oh, well, now we have an excuse for saying that that's, a mixed-use situation. If we just take a step back and understand that all these families before you are just like single parcel families, they should be treated like single parcel families. The case law does that. The ARL really does that. Ms. Hooper expressed her justification for the difference in treatment for single parcel and multi-parcel cases. She said, well, the single parcel must contain a residential dwelling. But of course, we have a dwelling on the assemblage here, and Fifield says that's good enough. That issue's been resolved. The other thing she said is that Sullivan requires dwelling improvements on both parcels, or some sort of improvements on each parcel to qualify. That's been repudiated in Fifield, and it was dictum. It's just an offhand word in pure dictum in Sullivan. So, we have dealt with the ARL. It is not intended to graft a new requirement on the statute for multi-parcel situations. We've dealt with the case law. Ms. Hooper didn't address at all the statutory language because it offers no support for treating the 2 contexts differently. Contiguous parcels in common ownership are to be treated the same as a single parcel. And let me just comment that those 3 elements provide corroboration for each other. When you have common ownership and contiguity, and they're used as a unit even for just enjoying the land, just loving it and having a little elbow room, there's an integrity to that that really makes sense. The wisdom of the General Assembly was in requiring all 3 elements to give residential classification to the assemblage, but there was no intent to have the used as a unit element be different in that setting. Thank you kindly for your attention.
Thank you, counsel, for your excellent arguments. The cases will stand submitted and opinions will issue in due course. That concludes the arguments for this docket.